Welcome to Building Families, Bridging Differences, a family law journey.
Hello and welcome to Building Families, Bridging Differences, a family law journey with Shelly Booth Cooley, the founder of the Cooley Law Firm. I'm your host, John Clements, and today's episode is Surrogacy and Donor Services, Navigating Legal Waters. So Shelly, welcome to the show.
Thank you. I'm glad to be here.
I'm glad you're here as well. So let's dive into it. What legal considerations should prospective parents be aware of when they're starting this journey of surrogacy or using donor services?
It is extremely important when you are considering building your family via surrogacy and or donation, be it egg, embryo, or sperm, that you are in a state that is friendly. And what I mean by that is some states are unfriendly to the surrogacy process, meaning you should not engage in surrogacy in that state. And with the personhood statutes that different states are attempting to pass, that has a detrimental impact on the surrogacy and donation field. And it would be extremely important to avoid those states when selecting carriers and or donors, because you could get into some legal hurdles that could impact your ability to establish parentage to your children.
Okay, so it sounds to me then that it's not only just the state that you reside in, but it's potentially the state where like all of the players live, the donor or anyone else involved. Is that correct?
Correct. But one thing to keep in mind when we're dealing with surrogacy specifically, as well as adoption, adoption is different, but you have to be aware of where do the intended parents live? Do they live in the United States? And if they live in the United States, which state? Do they live outside the United States? And if so, which country? Because there are some countries that surrogacy is illegal. And then as far as the gestational carrier or donor goes, we also need to understand she's likely going to be in the United States. We do have surrogates in other locations like Mexico, Canada. You could have a surrogate anywhere, but oftentimes when we're doing surrogacy in the U.S., we have surrogates here as well. But you also need to be aware of what does the state look like as far as are they surrogacy friendly? What is their stance on abortion and selective reduction? Some states have made it essentially illegal to have any type of abortion care, which when you're dealing with surrogacy and IVF and those type of treatments, abortion care is healthcare. And then also, what is the state where the child is going to be born? What are the procedures for establishing parentage? Because ultimately, what we're all trying to do is we're trying to make sure that when this child is born, that the intended parents, their parentage is established, and that there are no legal hurdles that they have to go through as far as establishing parentage.
Yeah, that sounds very complicated and very difficult to navigate without, an expert help like you coming alongside of them. So in your experience dealing with these issues and walking, families through this, what are some common misconceptions about surrogacy that could lead to complications later along in the process?
So I think one of the things that you need to be aware of when we're talking about surrogacy, most surrogacy arrangements are gestational surrogacy arrangements. And gestational surrogacy arrangement means that the gestational carrier is not biologically related to the child that she is carrying. With traditional surrogacy, the carrier or the surrogate is biologically related to the child she's carrying for the intended parents. Now, on the news, you see situations occasionally where there's an issue with the surrogate not wanting to deliver the child to the intended parents. That situation would be a situation that might occur when you're talking about traditional surrogacy, because the surrogate is related to the child. Traditional surrogacy is extremely uncommon. Nevada doesn't specifically allow it, but they also don't specifically prohibit it. We allow gestational surrogacy expressly in our laws. And the reason is it is a protection for the intended parents and the carrier, that there is no question as to who the parents of this child are. And in Nevada, parentage is established by intent. So if you intend to be a parent, you are in fact a parent, which is why we refer to intended parents as intended parents. They are the intended parents of the child the carrier is carrying. So that is one hurdle. Additionally, you want to know, and an important question to ask is, how is parentage established? In Nevada, we are able to obtain pre-birth orders. And what that means is that at approximately 20 weeks of gestation in the pregnancy, we file our parentage pleadings with the court to establish the intended parent or intended parents. It can be a single intended parent. It can be two intended parents. It can be more intended parents. Who are the intended parents of this child? And we get a court order indicating that the intended parent or intended parents are the parent of the child, and directing the hospital to allow the intended parents to act as the parents immediately upon the birth of the child, and that the intended parents' names are to go onto the birth certificate.
So, Shelly, talk to me a little bit about how can intended parents ensure that their rights are protected throughout the surrogacy process, and especially considering like their parental rights?
So when you are considering undergoing the surrogacy process, you need to be aware of where the child is going to be born. Some states are surrogacy friendly, other states are not. Some states are donor friendly, other states are not, particularly if they have personhood statutes and or prohibit abortion care. Those are very much part of the surrogacy process, as far as those are important issues that have to be discussed, and we have to make sure that all folks are on the same page. It's uncommon to have to utilize abortion care, but it does occasionally happen. And if so, we need to make sure that everyone agrees to what is going to happen and what the process is for that to happen. So you want to be very careful about where your child is going to be born, which also is where the surrogate lives. And then one of the questions that you want to ask when you're thinking about this process is, how does the state handle parentage? In Nevada, at 20 weeks, we establish parentage with a court. So we file a petition. We get declarations from the intended parents, the gestational carrier, her partner, if she has a partner, and then the attorneys file it. And then we get an order before the child is even born that says that the intended parents are the parents of the child, that the intended parents are to be allowed access to the child from the moment of the child's birth, and physical custody of the child from the moment of the child's birth onward, that they're permitted to leave the hospital with the child, and that vital records is to put their names as the parents of the child, not the carrier or her partner. In some states, the gestational carrier's name actually goes on the birth certificate, which would be quite troubling to me. It actually is quite troubling. And you have to have her name removed and then put the intended parents in place. There are some places that you actually may have to do an adoption proceeding. To me, those are unnecessary obstacles when you have some states like Nevada that are so surrogacy friendly, And we make it easy for anyone who wants to build a family here, regardless of marital status, sexual orientation, gender. If you want to build your family, you can do that in Nevada.
Yes, I think you mentioned in the last episode that Nevada is very surrogacy friendly, whereas other states may not be, and there's these challenges involved, in that kind of a situation. And I was curious to get your thoughts on what the legal contracts look like surrounding the surrogacy and donor situations. So how important is it that they're thorough? And then are there any key elements to make sure to include in these contracts?
The contracts are going to vary by state, and I'm only licensed in Nevada, so I can tell you what's required in a Nevada contract. So when you are negotiating a contract, it is extremely important that you have, at the minimum, an attorney who is licensed in the state where the surrogate or the carrier, we use those terms interchangeably, where the surrogate lives, who is going to give birth to the child. The intended parents, it's also important that they have an attorney from their state, but they can have an attorney from the same state as the carrier, or you can use choice of law provisions in Nevada for a number of bases. Those are legal issues, not quite so simple, so you've got to talk to an attorney about that. But if you can get Nevada to have jurisdiction, that is a fantastic way to go, because we do have such surrogacy-friendly laws.
So with all of those factors at play, are there any other key elements like in the contract that one should make sure is in the actual contract?
Yes, you are going to want to make sure that the contract specifies the how many embryos are being transferred. You need to make sure that it has abortion and selective reduction provisions, because that is not something that you want to have to discuss on the fly without having had a conversation beforehand. And the reason I say that is those conversations can be a little bit touchy and difficult. So you want to talk about those before you are in the middle of this process and emotions are high and you're hopeful and, there's excitement. You want to make sure that that's something that is discussed and understood before the process even begins. You want to make sure that you've got your compensation terms. Most contracts you have base compensation, and then you also have compensation based on events that may or may not occur. So you've got to spell those out. You need to make sure that in Nevada that both sides have counsel, and they have to be represented by independent attorneys. And depending on where you are, you will need to have your agreement notarized as well. So those are some of the things that you need to be very careful of, as well as declarations from each of the parties as to their understanding of the agreement.
Well, thank you for tuning in to Building Families, Bridging Differences, a Family Law Journey with Shelly Booth Cooley. To connect with Shelly and her team, head to CooleyLawLV.com. And don't forget to like, subscribe, and leave a review so we can get this broadcast to more people so they can hear more about what Shelly does. And so, Shelly, again, thank you so much for being on the show today.
Thank you for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.